The court ruled as unconstitutional this quota scheme that the legislature put out there, requiring that boards of directors fulfill some type of quota scheme based on race, ethnicity, and LGBT status. It was an historic ruling because it would be Katie bar the door if that court allowed it to go forward. Next up, in terms of good court news, is a big victory in California. I've been telling you about Judicial Watch's taxpayer lawsuits against the leftists in California who have decided that laws against discrimination, specifically in the California Constitution, don't matter anymore. And they were going to require, in a set of two laws, the first law that was passed, gender quotas on boards of directors for public companies. That if you're a publicly traded company, after a certain amount of time, depending on the size of your board, you had to have a certain number of women on the board. So that meant that there would be slots on the board that no man could apply for. Outright discrimination, obviously barred by law in the Constitution. But the radical left in California legislature and the governor didn't care, even as they were signing it into law. But the legislature and the governor, as they're considering this, they understood that it was constitutionally infirm. But the extremist left, they don't care about the rule of law, and they're just trying to see what works and what they can get away with. And what Judicial Watch did was we sued that law, on behalf of taxpayer clients. So taxpayers in California have the right to challenge laws like that when tax dollars are being used to pay for illicit activity, which is this discriminatory quota program. And so what happened is the legislature then doubled down and passed a second law. And the second law required discrimination and quotas on the basis of race, ethnicity, and LGBT status. That was similarly constitutionally infirm, but they didn't care and they passed it anyway. So what did Judicial Watch do? Judicial Watch filed a second lawsuit on behalf of taxpayers. And kudos to our clients who stepped forward here, our citizen clients in California. And in the first case, the gender case, we went to trial. And the trial, I've been talking about it if you've been following us, the trial just ended a few weeks ago, or maybe about a month ago. We don't have a decision yet. It lasted several weeks, but the court hasn't made a decision yet. It was before the judge, it wasn't before a jury. And so we expect the judge to make a decision soon. But in the second case, the case against the race quotas, we won! We won! We went to a hearing, as I disclosed to you before, where the court was considering motions for summary judgment by us and the defendants. And motions for summary judgment are essentially, we should win without a trial. And of course, the defense says they should win without a trial. And the court ruled as unconstitutional this quota scheme that the legislature put out there, requiring that boards of directors fulfill some type of quota scheme based on race, ethnicity, and LGBT status. It was an historic ruling because it would be Katie bar the door if that court allowed it to go forward. Because you can bet the left would have been right out there pushing for quotas all over the country. And here in this case, it was a state court judge who made the ruling based on the plain language of the Constitution in California and found the court or found the state's arguments wanting. So weak that he didn't need a trial to figure out what was up and what was down. And so he issued the ruling. It was last Friday. I think it was shortly after I did our weekly update last week. And, right? I don't think we talked about it last week, right? And so it was a one-page ruling saying, you know, I'm granting summary judgment. And boom, the news was all over the country. And then on Monday, we got a hold of the decision, which described his thinking. But I tell you, this is big news because this is a historic victory, as I said, that is going to set a precedent and have national implications. What did I say? You know, it's funny, I do these press releases and we think very carefully about what I'll say with respect to these big cases. And then I don't repeat myself on important videos like this. So I think it's worth highlighting what I said. This historic California court decision declared unconstitutional one of the most blatant and significant attacks in the modern era on constitutional prohibitions against discrimination. In its ruling, the court upheld the core American value of equal protection under the law. Judicial Watch's taxpayer clients are heroes for standing up for civil rights against the left's pernicious efforts to undo anti-discrimination protections. You know, and as we noted in one of our pleadings before the court, which is our motion for summary judgment specifically, and this is simple, laws that explicitly distinguish between individuals on racial or ethnic, sexual preference, and transgender status grounds fall within the core prohibition of the Equal Protection Clause. Indeed, a Senate floor analysis, this is the California Senate, produced during deliberation on the legislation, concluded that the bill draws distinctions based on race and ethnicity, and therefore it is suspect, and that the existence of general societal discrimination will not ordinarily satisfy courts. And then in the Assembly of California, they found that the bill would result in ongoing costs in the hundreds of thousands of dollars to gather demographic information and compile a report on this data on its internet website. So that is what, by the way, that's what you can't spend. That's where we come in and say, well, you can't spend money doing illegal activity like that to engage in discrimination as part of a mandate for discrimination. And what was the state's defense? Well, we're not enforcing the law. I mean, they're so proud of the law, they won't enforce it because they know it's suspect. So here is the decision that we were able to, the judge issued. It's a 24-page decision. And the title of the case is Crest et al. Versus Padilla. The legislature, and the court, I didn't agree necessarily with everything the court said, and you'll see why here. There's nothing outlandish or incredible about the idea that people generally tend to socialize with and select other people like themselves. The natural result of this tendency is the exclusion of people who look and act differently. And the natural result of that exclusion is the loss of the acumen that those different people would bring to a conversation, business, or any other group. The underlying premise here is that demographic diversity is a reasonable proxy for differing perspectives and life experiences. That premise is not seriously challenged by anyone involved in this case. I don't know if that's necessarily true, but it's what the judge said. If demographically homogeneous boards are a problem, then heterogeneous boards are the immediate and obvious solution. But that doesn't mean the legislature can skip directly to mandating heterogeneous boards. The difficulty is that the legislature is thinking in group terms, but the California Constitution protects the rights of individuals. And that's something the court emphasized directly. I'm not emphasizing this. It's in the decision. The rights of individuals to equal treatment. Before the legislature may require that members of one group be given certain board seats, it must first try to create neutral conditions under which qualified individuals from any group can succeed. That attempt was not made in this case. And that to me is an important insight. It's not like an important insight. It is an important insight, which is that the left wants to treat you as a member of a group. And of course, our Constitution doesn't generally protect group rights. It protects you from being targeted because you are a member of a group. But the core truth of the Constitution and the core genius of the Constitution is designed to protect our individual liberties. It sets up a structure of government to protect our individual liberties, not groups of people. And if you want to destroy your liberties, let the government tell you, you benefit or are punished because of a membership in a group. That's at odds with the American tradition and American rule of law. And that's what they were trying to do in California. Really radical stuff. So it's a lengthy opinion. I obviously can't read it all, but I'm going to read some of it because I know you're not going to read it all either. And this is a discussion of the Equal Protection Clause of the Constitution of California. Article 1, Section 7 of the California Constitution says, a person may not be deprived of life, liberty, or property without due process of law or denied equal protection of the law. A citizen or class of citizens may not be granted privileges or immunities not granted on the same terms to all citizens. Privileges or immunities granted by the legislature may be altered or revoked. So the point is, you all have to be treated equally in California. That's even stronger than the language of the Constitution of the United States. And there was a major case that the shorthand way of describing it is Connerly. And it's the governing precedent in California. A legislative classification satisfies equal protection of the law so long as persons similarly situated with respect to the legitimate purpose of the law receive like treatment. So again, no race-based favoritism, no race-based set-asides. Or in this case, race, ethnicity, and LGBT status. So they've even broadened it. And that, I'm not even getting into the question of the self-identifying nature of those categories that the left is now embracing, which kind of blows everything else out of the water in ways that, we could spend 3 hours talking through the ramifications of that. Legislative classifications generally are entitled to judicial deference. However, judicial deference does not extend to laws that employ suspect classifications, such as race. So think about this. It's like, well, you can say, well, that person lives in that jurisdiction and that person lives in that jurisdiction, and we're going to treat them equally and, or maybe someone will benefit more because they live in a different jurisdiction. But the idea that you say that person is this race and that person is that race, and then treat them differently, no. The courts look askance at that for good reason, as you might imagine. Because suspect classifications are pernicious, and are so rarely relevant to a legitimate governmental purpose, they are subjected to strict judicial scrutiny. I.e., they may be upheld only if they are shown to be necessary for furtherance of a compelling state interest, and they address the interest through the least restrictive means available. So, again, I'm not a lawyer, so bear with me here. In order for this type of scheme to work, the government has to prove, and it's up to them to prove, in my view, and I think legally it is too, but certainly it makes sense. It would be, they'd have to prove this, that, look, there is a compelling state interest here, and it's the least restrictive means available. So it can't be extreme or aggressive. And by the way, it's got to be really compelling what the state interest is. And what the government was saying is that, well, yeah, these are suspect classifications. The compelling state interests are the following. Remedying racial discrimination. And the other compelling interest is it's good for business. And if it's good for business, we'll get more taxes from it. And the court said, well, neither of those are good enough. And this is why. Yeah, so the court found that just citing general societal discrimination ain't good enough. You have to have specific instances of discrimination that would allow, and only then that might allow the state to say, well, yeah, this person was discriminated on the basis of race, John Smith, and therefore he has to be hired. Or, someone had this practice of excluding blacks from jobs because they were black. So therefore, there's a remedy that gives preference to certain job applicants who are black. That's a very narrow remedy. And obviously, there's no doubt, by the way, that these categories of suspect classifications, there's no doubt this law triggers the sort of scrutiny that we're talking about. It requires corporations to have a specific number of directors who are members of certain listed races or else have certain listed sexual orientations or gender identities. People of other races, orientations, and identities are necessarily excluded from these board seats. I really can't believe we're even having to talk about this in this day and age. I mean, first of all, we got the federal Constitution, the 14th Amendment that requires equal protection under the law. And then we've had subsequent civil rights statutes that have been passed in the decades after that, mostly in the 60s and such. And then the state variations of it and changes to state constitutions. And here we are, 60 years later, at least from the 60s, and they're trying to undo all of that, the left is. And with regard to the economic argument, it's good for business. Well, first of all, we beg to differ. Discrimination's never good for business. Because that's what this is about. This isn't a question of, oh, let's have diversity or let's have people from various backgrounds on the boards and think that's not the issue. The issue is, do you tell people you can't apply because of your race or because you have the wrong sexual identity? Of course not. And the court highlighted, if, under the idea that it's good for business, that means you could get the government to do anything in terms of mandating discrimination as long as they massage the numbers properly. So that was a big loss. So this is how the judge concludes. A member of the public, whom all three branches of government serve, might wonder at this result, given some of the concessions made in the record, and he's talking about the value of diversity. If the legislature has identified a social problem, how can the court stand in the way of the obvious and direct approach to solving it? There are two complementary answers to the question. The first comes from the differing functions accorded to the different branches. It is the function of the judicial branch to resolve disputes. Courts serve that function in part by maintaining the continuity of rules even against the will of a majority. Residents of all stripes can feel more at home and more at peace with one another if they know the rules are stable, even when they don't like those rules. The second is that fundamental values, whether personal or social, must be guarded. Equal treatment and opportunity of all and for all individuals, regardless of how they look or identify, is one of this state's basic commitments. Sometimes, and in some places, the citizens of this state will not live up to that ideal, meaning they'll engage in discrimination. But the thing that caused the problem, discrimination, is not always the right tool to fix the problem. Only in very particular cases should discrimination be remedied by more discrimination. And that should only happen after obvious alternative measures have been tried. Sometimes a direct approach should be the last resort, not the first. Now, this is the judge who wrote that. That's Judge Terry Green. He's a judge at the Superior Court in California. He's a judge in California. I don't necessarily agree with his analysis there in terms of how charitable he was to the California state legislature's pernicious racism or racial quota scheme. But his point is that if you're concerned about race in our nation's public life, if you want people to be treated according to the content of their character, you got to follow the rules, and you can't cheat. And you can't say this person gets a special benefit because of the color of their skin. And it's rare that I quote Chief Justice Roberts, or in this case I may misquote him, but I think I'm getting the general gist of his quote right. He said the way to end racial discrimination is to stop discrimination based on race. I mean, the solution to race discrimination is not more race discrimination. And to be clear, as we litigated in the gender case, and we were prepared to litigate, and I think our expert probably would have been able to refute any arguments in this regard, they didn't really have evidence that there was discrimination. The highlight of the court's decision, or one of the highlights of the court's decision, was, They were talking about racial discrimination generally. Well, they didn't because there wasn't enough numbers on the boards that fit in with the demography generally of race in California. Well, A, they were using national numbers, but B, they weren't looking at the group from which corporate board members are selected. So there was like a gamesmanship even with numbers. They couldn't even prove discrimination, let alone the level of the specific direct discrimination that would have resulted in a narrowly tailored remedy that would have allowed potentially for certain acknowledgement of race in certain hirings. So this is a big decision. And as I said in our subsequent release on that, describing the court's findings here in our California case, and as I said in one of our other statements about this case, California must treat its citizens equally everywhere. Every state should do that under the law and not give discriminatory preferential treatment to some based on race, ethnicity, or LGBT status. The court ruling marks a watershed for the core American value of equal protection under the law for all Americans, and it warns against the pernicious racialism of the radical left. And what's interesting about this is the media reaction to it, because they really don't know what to say or do, because there is no legal justification for what went on here. I mean, I'm excited about this ruling, but I don't know what, I can't imagine we would have lost or should have lost, but you never know with the courts. So, I mean, it was clearly illegal. It was clearly unlawful what was going on here. As I highlighted, the governor and the legislature, they knew it was likely to be found unconstitutional. So, A, the headlines were, court rules against California's diversity requirements. Well, that's a nice way of saying, quotas. But secondly, the general left's approach now is, we can't have government mandates maybe, but maybe we can get private mandates requiring discrimination on the basis of race and these other qualifications or other categories. So now the left is pushing the idea that we'll have private pressure and private investors will get the big Wall Street firms to force corporations to hire people based on race. Well, that's not legal either. This is pernicious, and it's not going to stop with this victory, unfortunately, because as I highlighted, the left says, okay, well, we'll just do this privately. Well, you can't discriminate on the basis of race in hiring people. I mean, do I have to explain that? But they don't care. They don't care, and they're continuing. I mean, Judicial Watch objected to this reporting requirement for boards of directors in the NASDAQ stock exchange. A reporting requirement that would have pushed, obviously, for categorizing people based on race, and then implicitly hiring them based on race and other categorizations. Again, suspect categorizations. And, the Biden, forget about that joke. I sometimes get confused about who's running which administration. So the Biden Securities Exchange Commission blessed that. And then we have the NFL out there saying that they're going to require NFL teams to have a specific coaching position that can only be filled by someone of a particular race, or I don't remember if it's gender too or not. I think it was just race. Again, outright discrimination. So they're planning to violate the law. And of course, this Biden administration supports this. CRT, and this is critical theory, by the way, the idea that only by having someone of a different skin color are you blessed, are you vindicated, or is your organization valid? Obviously, that's not true. The question is, are you discriminating on the basis of race? And if you're not, it's no one else's business. It's no one else's business. But the critical theorists, they believe it's always their business. And if you don't agree, they'll come after you.
Thanks for tuning in. Be sure to subscribe to our YouTube channel to catch all the latest news from Judicial Watch.